Alternatively, if the defendant is found to be competent, counsel hereby simultaneously requests that the defendant undergo an evaluation to determine if she is not guilty by reason of insanity, because she was suffering from a condition which would produce legal insanity at the time of the alleged offenses. Defense counsel makes this motion in good faith to determine defendant's mental condition at the time of the offenses charged and whether the defendant is competent to stand trial on the offenses charged. The reasons for this motion are more fully explained in the attached memorandum in support, which should be incorporated herein. So let's take a look at his memorandum in support. Now, keep in mind, this comes after the defendants, the remaining three defendants, the other three defendants have already asked for competency evaluations. I was kind of like expecting this and wondering why hasn't he filed for one of these? I mean, is he still meeting with her and just kind of sizing up the situation, seeing how she comes across? Why is Tommy Stolle not filing for this? It seemed like everybody else had questions about the competency of their client or are laying.
The judge had one question for the defense attorney. What exactly had he observed that made him believe his client could not understand the proceedings against her? The answer did not go into the public record. It was sealed, kept from the prosecutor, kept from the press, kept from the family of the 16 children who had been found living in a room covered in human waste. The lawyer, Tommy Stolle, had filed a motion asking the court to evaluate Elizabeth Ciders for both competency and insanity, but he specifically requested that his reasons remain private. He told the judge he would provide a detailed accounting of his concerns, off the record, not because the law required secrecy, because what he had seen, he said, was that significant. Picture a photograph of Elizabeth Ciders from 2020. Blonde hair, clear eyes, a young woman smiling next to her mother on a birthday post. Now picture the photograph taken the day she arrived at the Vinton County Jail. Gaunt, hollow, unrecognizable. The two images are separated by 6 years, but they are separated by something else: 18 pregnancies, 16 living children, and a legal system that is now trying to decide.
Everybody except for Elizabeth's attorney had filed motions recently saying we need a competency exam of our clients. We need their competency evaluated. We fear in dealing with them and talking with them that they just don't understand the process, what's going on. They can't assist me with their defense. This is what their lawyers are saying. Well, everybody filed one of those up until this week, and with the exception of Elizabeth, her lawyer didn't file one of those. Well, guess what? This week, Elizabeth Ciders' lawyer, Tommy Stolle, finally filed a motion seeking a competency evaluation for Elizabeth Ciders. Also, he filed a motion in the alternative saying, look, I want her evaluated for competency. If the examiner determines she is competent and can assist with her defense and understands what's going on, I want her evaluated to determine whether or not she suffers from some mental illness or mental disease or defect that would make her legally, under the law, insane at the time that these offenses occurred. Meaning that she was so mentally ill at the time that these child endangering charges happened that she didn't understand what was happening was wrong. So I'm going to pull up that motion and show it to you, because there are a lot of questions here that we don't have the answers to. We don't know why they first went there, what evidence of what crime they were looking for. We know that this is Elizabeth on June 30th of this year. Look at her. This is Elizabeth several years ago on her mom's Facebook page. Back in 2020, this is an undated photo. This is Elizabeth with her mom wishing her a happy birthday. So how did Elizabeth Ciders go from this, looking well, blonde hair, I mean, she's a pretty girl, to this? What on earth happened? What went wrong? Aside from her giving birth to 18 children over 18 years. I mean, that's enough to wear anybody out, right?
Whether that woman is a monster, a victim, or something far more complicated, the system erased her first. Before we go deeper into what the documents actually show, make sure you're subscribed to Crime Files 91, because we don't just cover the story, we follow the evidence. On June 30th, deputies with the Vinton County Sheriff's Office and agents from the Ohio Bureau of Criminal Investigation arrived at a home in the village of Hamden armed with a search warrant. The warrant was not for child endangerment, It was not for the 16 children they would find inside. The original warrant was tied to 4 misdemeanor counts,
all facing child endangering charges after police, I should say the Benton County Sheriff's Office and agents with the Ohio Bureau of Criminal Investigation went to a home in the village of Hamden where this family was living back on June 30th. They went there armed with a search warrant. Okay, they had a search warrant separate from an arrest warrant for Gary Ciders Jr. up in the upper left-hand corner there, the younger man. They had a warrant for his arrest for 4 misdemeanor counts of public indecency where he was exposing himself. That's the allegation, the accusation that he was exposing himself on 4 different occasions, starting on May 23rd of this year, going to May 31st of this year. What I think is interesting about that is that May 23rd was the Saturday of Memorial Day weekend. So that would have been a 3-day weekend. Did this potentially involve children? I don't know. Kids off school riding bikes? I don't know. It's just a thought that has crossed my mind. We have no idea why the cops went there with the search warrant. It appears to be separate. I know people have said, but the release on the sheriff's website said allegations of domestic abuse and this, that, and the other. That said that, and it was actually a press release from the Attorney General's office. But on that same date, the press release the Attorney General's office sent out did not include that information. And it was authored by the same person. So I don't even know if that is accurate. That could have been edited and later sent out. And this may have nothing to do with allegations of domestic abuse. Okay. We just don't know yet. But the investigation is ongoing. They go in there with the search warrant looking for evidence of a crime not related that we know of to the public indecency charges. And they find 16 kids. And they have to go get a second search warrant for the 16 kids because they've walked into the house and they're like, holy smokes, what is going on? There are 16 kids in one room. Oh my God. They get the kids out of there. They take them to the hospital and they've got a child endangering case on their hands. So they then have to go get another warrant because the warrant they originally went there with didn't cover the children in investigating a crime related to child endangering. So there were 2 different warrants executed at this home back on June 30th.
Of public indecency against Gary Ciders Jr., allegations that he had exposed himself on 4 separate occasions starting May 23rd of this year. But when law enforcement walked through the door, they discovered something no warrant could have prepared them for. 16 children, ranging in age from 6 months to 17 years, living in a single room. Trash, bugs, feces, and urine covering surfaces. One child so malnourished and sick that medical staff later said if they had gone another day or 2, they would have died. The deputies had to obtain a second search warrant on the spot because the first one had not anticipated the scope of what they had just walked into. The family had been living in Benton County, the least populated and one of the poorest counties in Ohio, with an annual county operating budget of just $8 million. The county government itself runs on less money than some school districts spend on athletic facilities. And within that county, in a village with no traffic lights and no grocery store, 16 children had been hidden from the world. Now, 4 members of the Ciders family faced child endangerment charges. Elizabeth, the mother, Gary Jr., the father, and Gary Stur and Christina, the grandparents, all have pleaded not guilty. But here is where the frame freezes. Because Elizabeth's attorney did something the other defense attorneys had already done weeks earlier. He filed a motion requesting a competency evaluation for his client to determine whether she understands the charges against her and can assist in her own defense. And then he added something the others did not. He requested that if she is found competent,
would make her legally under the law insane at the time that these offenses occurred, meaning that she was so mentally ill at the time that these child endangering charges happened that she didn't understand what was happening was wrong. So I'm going to pull up that motion and show it to you because there are a lot of questions here that we don't have the answers to. We don't know why they first went there, what evidence of what crime they were looking for. We know that this is Elizabeth on June 30th of this year. Look at her. This is Elizabeth several years ago on her mom's Facebook page. Back in 2020, this is an undated photo. This is Elizabeth with her mom wishing her a happy birthday. So, how did Elizabeth Ciders go from this looking well, blonde hair? I mean, she's a pretty girl to this. What on earth happened? What went wrong? Aside from her giving birth to 18 children over 18 years, I mean, that's enough to wear anybody out, right? But something has happened. Something is terribly wrong. So let's look at this competency motion for a competency exam.
She be evaluated to determine whether she was legally insane at the time the offenses occurred. The legal bar for not guilty by reason of insanity in Ohio is a preponderance of the evidence, meaning the defense must prove by more than 50% that she suffered from a severe mental disease or defect that prevented her from understanding the wrongfulness of her conduct. It is a high hurdle, but the motion itself contained a telling detail. Staley wrote that he had met with Elizabeth.
Counsel was appointed on July 2nd to represent the defendant. Okay, we can move past that. On June 30th, the defendant was charged. We already know that. As of the filing of this motion, the defendant has not been indicted, and therefore counsel does not have all of the facts, evidence, or circumstances of this case or the defendant's subsequent arrest. However, in the interim, counsel has met with the defendant on numerous occasions and for extended periods. So he's saying he's met with her on numerous occasions and for extended periods. So I'm assuming that means several hours, many hours. He spent a lot of time talking with her, trying to gather information and trying to figure out what in the heck was going on in this house on Omer Street, in other houses where this family lived, and from the time that she married into this family at the age of 15, which is still just boggles my mind. During these interactions, counsel has been able to observe the defendant's demeanor, conduct, and comprehension. These interactions lead counsel to believe that the defendant may be suffering from significant mental health issues and that competency may be an issue and a clear impediment to the defendant's ability to assist in her own defense. Counsel is prepared to provide a more detailed accounting of his concerns and the specific conduct giving rise to those concerns directly to the court and eventually to the evaluating medical professionals. So he's saying directly to the court. He's signaling, I'll let you know what I'm talking about, Judge, but I'm not handing this over. It doesn't sound like he wants to hand this over to the prosecutor. It doesn't sound like he wants to file this information publicly.
On numerous occasions and for extended periods, he observed her demeanor, conduct, and comprehension. And those interactions, he stated, led him to believe that competency may be a clear impediment to her ability to assist in her own defense. He then added that he was prepared to provide a more detailed accounting of his concerns directly to the court, not to the prosecution, not to the public file, only to the judge. That is not standard. That is a signal. The system erased them first. Think about what that means. A defense attorney trained to see the best possible narrative for his client is telling a judge that he cannot publicly describe what he has witnessed because it is too damaging, not to his case, but to his client's privacy, or perhaps to the case itself. He is playing his cards close to the vest. But the question is, what cards does he actually hold?
But maybe they all got together and they're like, look, mental health is the way to go here. We've really got nothing else. I mean, come on. They didn't have the kids in school for years. You had 16 kids in one small house living in squalor. These attorneys, a couple of them have called it extreme poverty, which it very well may be. But I think we can all agree you can live in poverty and still be clean. Oh, pardon me. Excuse me. I got to sneeze there. You could be poor and be living in poverty and not have trash and roaches and bugs and feces and urine all over the place. I mean, it's just really sad and really hard to believe. I mean, that's Elizabeth the day she got to the jail. So I really wanted to talk to Dr. Bober. He is a forensic psychiatrist that we interview quite often at Law and Crime. And I did interview him about this. And I found it to be incredibly interesting what he told me about this whole thing with regard to Elizabeth. Really, Elizabeth is going to hold a lot of the keys here. Like, did she feel like she was under duress in all of this? Her brother, Jeremy, one of her brothers, basically said that she was indoctrinated. He's been saying that for a while now, that she was indoctrinated. Indoctrinated into what? He basically said she chose this family, she was indoctrinated, and that here we are.
Elizabeth Ciders was 15 years old when she married Gary Junder. She was 7 months pregnant. She gave birth 2 months later. Her own brother has stated publicly that she was badly beaten as a child, that she got pregnant to escape her own home, and that she was indoctrinated into this family. Indoctrinated, that word has surfaced repeatedly. But indoctrinated into what? There are signs that point toward a religious component. Christina Ciders, the grandmother, has posted religious imagery and crosses on her Facebook page. Photographs from inside the Hamden house show writing on the walls, including a phrase scrawled next to a single painted eye: "God protect him." The house itself was so damaged that drywall had been ripped from the walls. A stove was covered in bugs. The conditions were not just poverty. Poverty does not require writing on the walls. Poverty does not require a child to be so sick they need intubation. Poverty does not require hiding 16 children from the government for years. This was something else, and the defense attorneys know it. Dr. Bober, a forensic psychiatrist, has weighed in.
Thank you so much.
Dr. Bober, there's been a lot of talk about Elizabeth Ciders potentially being a victim here. She was 15 years old when she was married. She was 7 months pregnant, it appears, at the time that she was married, gave birth 2 months after she was married in 2008. And then we know what happened after that, all these other pregnancies. Is it possible that Elizabeth Ciders is both a victim and somebody who is guilty of child endangering?
So it's a very interesting question. I think this case, more than a lot of the others, really shows the interface between mental health and law. And it really demonstrates how when you take the same set of facts, whether you're the prosecution or the defense, you can tell a very different story. And as you pointed out in the beginning, here we have Elizabeth, who marries Gary, herself a child, 15 years old, goes through 18 pregnancies. I think she lost 2 that were conjoined twins. Mm-hmm. And you have to ask yourself, was Elizabeth groomed? Was she isolated? Was she controlled? Was the activities of the family dictated by her husband and the in-laws? She may have been trapped in an environment in what we call coercive control, where she was subject to manipulation, isolation, and didn't really have anyone to turn to. And when I said how you can take the same set of facts and tell a very different story, the prosecution would say, hey, she could have left anytime she wanted to. She could have asked for help. But we know there is a well-known psychological phenomenon called battered woman syndrome, which is not an official diagnosis in the DSM. And obviously, I have not examined her personally. But in this particular syndrome, we can see the effects of learned helplessness, believing that there's no way out, trauma bonding, where you become psychologically dependent on your abuser, and a situation where you're hypervigilant, you're always looking for threats in the environment, and you don't really feel like you can leave. And this is why a lot of people in the public will say, well, why did she just leave? Well, this is the reason. So it will ultimately come down to, I believe, a battle of the experts in this case to show that Elizabeth may not have had the psychological mechanisms or abilities to leave this relationship and may have had less culpability than the prosecution may believe.
On this case, noting that Elizabeth may have been groomed, isolated, and subjected to coercive control, he referenced the concept of learned helplessness and trauma bonding, psychological mechanisms that make it nearly impossible for victims to leave their abusers, even when escape is physically possible. The prosecution will argue that she could have left.
The strange dichotomy, also made this choice to go with this family.
Right. So if we look at her as a perpetrator, what we see is that no matter what she was going through, she had a fundamental duty to care for her children and not allow 16 children to live in a 12 by 12 room in human waste. But if we see her as a victim, then we say, but due to her intense abuse, control, manipulation, that, as you say, she was indoctrinated. So maybe the choice wasn't completely hers. If they're going to try to use battered woman syndrome, they're going to need to link it up with expert testimony. And in the state of Ohio, if they're going for the insanity defense, they're going to need to show that because of a mental illness or mental defect, that she did not appreciate the wrongfulness of her actions. And in that situation, the obligation is on the defense to prove it by a preponderance of the evidence. So it's going to be, I think, a high bar if they're going for the insanity defense, which is usually associated, by the way, with use of force and not child neglect or endangerment.
Let's look at not guilty by reason of insanity in the state of Ohio. Let's pull that up real quick. So a person is not guilty by reason of insanity relative to a charge of an offense only if the person proves by a preponderance of the evidence, that's like, beyond a reasonable doubt's like more than 95%. So you'd be like this, preponderance of the evidence more like this, like a little over 50%.
At any time that she had a fundamental duty to care for her children and failed. But the defense will argue that she was a child herself, married at 15, pregnant at 15, and trapped in a cycle of abuse that she did not create and could not escape. The battle of experts will define this case. But here is the uncomfortable question that no expert can answer. Was Elizabeth Ciders a perpetrator who knowingly neglected her children? Or was she a victim who was too broken to understand that what was happening was wrong? And the even more uncomfortable question, does the answer even matter to the 16 children who were found in that room? Before the June 30th raid, the family had already attracted attention from authorities. In October of 2021, the Gallia County Local School District filed truancy complaints.
Basically, what he told me was that, and when I say he, Philip Kuhn at the Gallia Local School District, that is where the children, 6 of the oldest Ciders children, were enrolled at Ataville Elementary School in the 2021-2022 school year. That's when, in October of 2021, the Gallia Local School District filed truancy complaints for the 6 oldest children against Gary Jr. and Elizabeth Ciders because the children didn't go to school at all that year. Not one day of school. So they go, the sheriff's office goes and they try to serve the complaints. They can't find them. They're not at the house on Honeysuckle in Cheshire where the family had been living. The family, according to the guy that owned the house, trashed the house. There was feces all over the place, urine, and it was not just animal feces, human feces as well. Place was trashed. So this is the time, October 2021. We know before that time, Elizabeth, Gary Jr., and then the older Ciders had moved from Gallia County up to Vinton County.
Against Elizabeth and Gary Jr. for the 6 oldest children. The children had not attended a single day of school that year, not one day. When sheriff's deputies went to serve the complaints, the family had already moved. The landlord later described the house they left behind: feces, urine, trash, destruction. The family had simply relocated 1 county north and continued as before. But here is the part that should make you pause. When the Gallia County Schools superintendent spoke about the case, he revealed something striking. In the 2020-2021 school year, Elizabeth had enrolled the 6 oldest children in the district's online school. She did so on August 26, 2020, right up against the deadline. That suggests she was reacting to something, perhaps contact from child services, perhaps a threat of legal action. The children participated in online schooling for that 1 year. But the following year, when schools reopened for in-person instruction, they never showed up. Not for 1 day. And before 2020, the superintendent confirmed that the children had never been enrolled in school at all. The oldest child was 12 years old and had never received formal education. Gary Jr. had never attended Gallia County schools either. Elizabeth herself had withdrawn at age 15, with a notice that she would be homeschooled. Homeschooling in Ohio, by the way, requires nothing more than a notification.
You have to tell the district and notify them, and then apparently you can just do whatever the heck you want. I couldn't believe it when Philip Kuhn told me that this week when I interviewed him. So Elizabeth is the one that enrolled the children in the online school in 2020. The following year, they were supposed to go to Ataville Elementary, and they never showed up, not even for 1 day. So Elizabeth, she had once attended Gallia local schools. She withdrew at age 15, and notice was given to the Gallia local school district that Elizabeth would be homeschooled. So did Elizabeth ever get a diploma or a degree from being homeschooled? Who was homeschooling her? She had a baby at the end of May in 2008, 2 months after she got married. Who was homeschooling Elizabeth? Because she married Gary Ciders at the end of March. Was Christina Ciders homeschooling Elizabeth? Was Christina Ciders homeschooling the 6 older children. What in the heck was going on? We don't know. But I'm thinking the Children's Services contact in Gallia County is likely what prompted Elizabeth to enroll her children in the Gallia local school district online school on August 26th.
No curriculum review, no standardized testing, no licensed teacher oversight. You can simply decide your child has graduated and print a diploma. The superintendent called it educational neglect. He is right, but here is where the forensic examination becomes uncomfortable. Because if Elizabeth was so mentally ill that she could not understand the wrongfulness of her conduct, how did she know to enroll the children in online school when authorities came calling? How did she know to file the right paperwork, meet the deadline, keep the family just under the radar? Those are not the actions of someone who is completely disconnected from reality. Those are the actions of someone who understands consequences, who can calculate risk, who can navigate bureaucratic systems when necessary. And that brings us to the central paradox of this case. The defense is arguing that Elizabeth was so impaired that she could not appreciate right from wrong, but the evidence suggests she knew exactly what she was doing when it mattered. When the system was watching, the system erased them first. If the insanity defense proceeds, the prosecution will point to those actions as proof of awareness. The defense will point to her history, her age, her isolation, but neither side will be able to answer the question that matters most. Why did no one intervene sooner? The children were not enrolled in school before 2020. They were not seen by doctors. They were not reported by neighbors. They existed in a county with an $8 million budget and no resources, in a state where homeschooling is the Wild West, in a system that did not even know they existed until law enforcement stumbled upon them by accident. And that is not a failure of one family. That is a failure of a system that made it possible for 16 children to disappear for years without anyone asking where they were. The motion for competency and insanity evaluation is now before the court. The judge has ordered that the evaluations be completed within 30 days. If Elizabeth is found incompetent but restorable, she could be sent to a hospital for treatment. If she is found incompetent and not restorable, the charges could be dismissed. If she is found competent, the insanity defense will proceed to a trial where experts will argue over whether she knew her actions were wrong. But none of that will answer the question of how this was allowed to happen in the first place. The Gallia County Schools superintendent told us that the change in Ohio law in October of 2023 made homeschooling even less regulated. Before that, parents had to submit a curriculum and have a licensed teacher sign off. Now, they simply notify the district and walk away. That is not a loophole. That is a door left wide open, and the Ciders family walked through it. So what do you think? Is Elizabeth Ciders a woman who was so broken by abuse and isolation that she could not understand the harm she was causing? Or is she a woman who understood exactly what she was doing and simply believed the rules did not apply to her? The court filings are public record. The motions are available for anyone who wants to look. Read them, and then ask yourself this question: if the system had been paying attention, would those 16 children have ever been hidden in the first place? If you found this analysis valuable, like this video, share it with someone who needs to understand how the system really works, and subscribe to Crime Files 901 so you never miss an evidence-based breakdown. Turn on notifications, because we don't just cover the story, we follow the evidence.